Hello, I'm Corey, and I'm going to be talking to you about Chapter 8, The Law and Legal Professionals from our course textbook. So, this chapter examines some of the basic issues concerning the role of the law in society while presenting the formal and informal ethical codes that guide legal professionals' actions. So, the role of law. We all know that laws serve as the written rules of society's ethics and morals, with two sections, which are natural law, which refers to the belief that some law is inherent in nature and not human made, and positivist law, which refers to laws written and enforced by society, which are human made. The issue with laws is that they aren't broad in defining moral behavior. We have laws that deter negative behavior, but we don't have a lot of laws that promote good behavior. An exception to this is Good Samaritan law, which is commonly used in Europe, where if you see someone in needing of aid, you are prohibited to leave until you are able to assist them or until help is there to help. Laws also work on controlling behavior and provides protection for individuals. There serves as a social contract where individuals give up their utmost freedom in exchange for protection. So, justifications for law. A major justification is prevention of harm. This ties into the social contract theory that I was mentioning earlier, where law is a contract. We give up some liberties for protection. How does this tie into prevention of harm? Preventing harm of others is a harm principle proposed by John Stuart Mill, where everyone should have the utmost freedom unless they harm others. This is tied into more violent crimes like murder, homicide, property crimes, stuff like that. Preventing offensive behavior is not necessarily harming others, but giving rise to offense, i.e., public lewdness or disturbing the public. So, continuing off with justifications, we have preventing harm to self. We have legal paternalism that are laws that protect individuals from hurting others. An example of this is seatbelt laws with California's click it or ticket, where if you don't have a seatbelt on, you will get fined for it. Paternalistic laws can be supported by an ethics of care, similar to that of a mother nurturing a child. Preventing harm to societal morals, aka legal moralism, is a law that allows for protection and societal morals. Examples of this are gambling, suicide, and drug abuse. Changes in drug laws and same sex marriage laws show a morality shift. So, constantly we are seeing a morality shift. Like back in the day, we saw a bunch of people with cigarettes in hospitals, pregnant people, even children. But now there's an age limit. There's no more of that. Same with same-sex marriage. Before it was seen as something obscure or different, and now it's being more widely accepted morally. This is tied into a concept that the book mentions called gray areas that can cause debates over the moralisms and justifications of it. So, paradigms of law. There are three types the book mentions. One of them is consensus paradigm that views society as a community consisting of like-minded individuals who agree on goals important for survival. This law serves as a tool of unification. We have conflict paradigm that views society as being made up of competing and conflicting interests. This is tied to more corporate ideals, where governance is based on power. This law is seen as a tool of power where holders are to maintain and control the status quo. And we have pluralist paradigm, where the perception that society is made up of competing interests. This views the laws as influences by interest groups that are in flux, so more of a lobbyist group. An example of this that I put down that the book also mentions is immigration laws, where one lobbyist group would want it to be ABC, while another lobbyist group would want it to be XYZ. First, let's kill all the lawyers is a quote by Shakespeare, where it mentions that public perceptions have a distrust and or little confidence in lawyers, with research statistics showing that 18% indicated attorneys possessed a high or a very high standards of honesty and ethics, where 47% rated police officers as having high or very high standards. These are normally seen as lawyers typically representing trouble. Since a lot of lawyers that are being used are more public defense attorneys, you don't know who you're going to get and you don't know if they're going to represent you very well. And if they are they going to represent you morally or are they going to represent you unmorally? The book also mentions that I think is a very important thing that law can be used as a tool of oppression or a sword of justice. Lawyers and judges wield this power. Depending on how they use it, is either going to be advantageous to the client or disadvantageous to them. Law and the legal professional. So, indigent defense refers to poor people that are unable to get a private attorney, where 80% of all criminal defendants utilize a publicly funded attorney to do indigency. This is an extremely underfunded system, where some states even charge the defendants. And a statistic that the book mentions is the Department of Justice fiscal year in 2009, 20.8% million went towards prosecution, where 3.1 million went to public defense. Private attorneys can usually give better representation since they're more scheduled and they have more one-on-ones and not a lot of clients. This is seen as the best option, but most people can't normally afford it. The worst option being court-appointed attorneys, since they're usually free and they pick up a lot of cases, so this is seen as the worst option since you're not going to get the best representation in the trial. The criminalization of poverty refers to municipalities and counties trying new ways to raise revenue from individuals, examples being traffic tickets or fines. Poor people are jailed for non-payment of courts and fines, traffic fines being raised over time, and surcharges. Courtroom work groups refers to more of a play, where everyone is an actor. An example of this is the bureaucratic justice, where each case is treated as one of many. Actors merely follow the rules and walk through the steps, while the goal of this is bureaucratic efficiency, not justice. This can lead to procedures that contribute to a perception of unfairness, which also leads to the wedding cake illustration that the book mentions, where each crime is referred as a layer of cake, where the broader ones are more non-serious crimes, more broader crimes that is more expandable, while as each layer goes, it's more serious as it goes up and up. So, legal agent or moral agent. Lawyers believe that loyalty to the client is imperative to their duties as professionals. But there are discussions that talk about attorneys that should not abandon their moral compass as well. The types of positions between clients and attorneys are legal agent, where attorney and client are equal as one. No one is greater than the other. Special relationships refers to a client and attorney having a more trusting relationship like a trusted friend or a family member. And moral agent refers to the attorney having to follow his or her own moral compass. There is a different typology by Schaffer and Cochran that the book mentions, which is the godfather that promotes the client's interests, a hired gun that does what the client wants, a guru that controls the clients with their own moral compass, and the friend engages with the client in moral dialogue and convinces a course of action. Continuing off of that, there are debates over the legal agent position, putting a lawyer's moral decisions being put first or not. One can't be virtuous when pursuing a client's objectives, with the statement being, I'm a person first and a lawyer second. The position is that it's impossible and unethical to substitute one's own moral code for one's clients. Ethics for legal professionals. So, ethical guidelines for lawyers. There is a model code, which is the Model Code of Professional Responsibility that was created by the American Bar Association, which is the formal ethical standard for lawyers. These rules require attorneys to protect and pursue a client's interests within the boundaries of the rules. Ethical guidelines for judges. There is a model code that is specifically for judges that is also written by the American Bar Association, which is the Model Code of Judicial Conduct, which is for ethical considerations. The main theme between judges is impartiality. Does the judge have bias? Bias is a huge indicator in trials. Is the judge going to include their own opinions and ideals before the evidence being presented, or are they going to follow the evidence first before their own moral compass or before their own bias? So, culture and ethics. Issues that relate to ethics in regards to legal professionals is that model rules require a lawyer's conduct should conform to that of the law first. Major pressure in many offices to conflict formal ethics is the culture of winning. So, would you put your ethics first in order to win, or would you put ethics aside and do that in order to win? And lastly, ideals that the defendant is guilty can lead to cynical and unethical behaviors. This refers to as if you view the defendant as guilty, they can have cynical and unethical behaviors from the prosecutors and public defense attorneys. Public defense attorneys are there to help them, but they also want to not disregard the system that are also appointing them as well. And that's all I have for you today. Thank you so much.